All right, welcome everyone. My name is Morgan Greenleaf, and I'll be your host for this webinar of a Bench2Market talk all about intellectual property, protecting your innovation. These Bench2Market talks are once a month and are co-sponsored by Biolocity, the Georgia Tech Parker Pettit Institute for Bioengineering and Bioscience, and the Georgia CTSA, of which I'm a part of. First, a couple announcements before we get started. There are some resources available from Biolocity that I want to make you aware of. First is legal office hours. This is a great program that's a pro bono legal office hours offered by Professor Nicole Morris. If you'd like to have a consultation with Dr. Morris, for any of these topics here, you can make an appointment by going to the Biolocity website under legal office hours. There are also innovation office hours. So the entrepreneurs in residence from Biolocity are available pro bono for these office hours. Again, you can contact Biolocity directly to schedule these. Next is a funding opportunity from BARDA. BARDA is a large funding organization as part of the government that's all about preparedness. And they have different areas here that you can see on the screen. So if you are working in any of these areas and you are interested in non-dilutive grant funding from BARDA to commercialize your technology, you can contact the Biolocity team to learn more about this application. Our next talk will be next month, which is all about building a compelling pitch and pitch deck. So if you want to save the date, that'll be February 19th at noon. All right, so we are super lucky today to have Sarah Wilkinen and Dan Bruzone, who are joining us from Merchant and Gould. They're going to give us an amazing presentation all about intellectual property basics and strategy. And I'll say a few things. One is we will share the material after the presentation, and we will also be taking questions. So we'll have time at the end of the webinar. You can put questions in the chat or in the Q&A section, and we can answer those questions. And I'll also mention, besides Sarah and Dan, we have a representative from Georgia Tech Office of Tech Transfer, Kashmira Kulkarni, and also a representative from Emory Office of Tech Transfer, which is Caitlin Taylor. And I realized, Kashmira, that Tech Transfer Office has a different name at Georgia Tech, which I probably butchered, but maybe you could put it in the chat.
No worries. Yes.
And so with that, I'm going to turn it over to Sarah to begin our talk today.
Perfect. Here we go. All right. Can people see my screen?
Yes.
Wonderful. Well, thanks everyone for joining us today. Me and my colleague Dan Bruzone, we're going to talk through the basics of protecting your innovation. We'll go over a little bit of various forms of IP and how they can be combined to create a powerful product for your business. So I'm Sarah. I'm based in Atlanta. I earned my PhD at Emory, and I have prior experience in the tech transfer offices of Georgia Tech and Emory. And some of my hobbies are I like to travel. I like to hang out with my family and read and go on runs. Dan?
I'm Dan Bruzone. I'm actually coming to you today from all the way up in Minnesota, where I work in our Minneapolis office. My background's in physics, so a little bit different from the biotech area, but worked with startups in the biotech industry as well. I've been doing patent law for about a decade, a little more than a decade, after spending some time in corporate life at 3M doing some product development. So that's why IP became near and dear to my heart.
And hobbies?
Oh, right. Yeah. I guess in the last year or two, getting more outdoors. I've got a new cabin, and it absorbs all of my spare time, learning how to take care of that and make wood fires and do my own re-roofing and all sorts of things like that. So DIY projects, I'll call that a hobby.
Keep all your fingers, please. Need that for typing. Well, this is the typical disclaimer that's provided in most of these talks, basically setting forth that this is not legal advice, but if you have any questions after this talk, feel free to reach out to us and maybe hire us as attorneys. So happy to take that on. So Dan, kick us off. Why should we care about intellectual property?
Yeah, absolutely. Especially in the startup phase, intellectual property is really crucial to protect you as you're trying to get your company launched. There's a few items in this bullet point list. I'll just go over them briefly. Revenue generation, sometimes you might license your IP. Sometimes you might sell IP if you create IP that you're not going to use. You can use it as collateral both to get investor interest in your company, or if you do end up, we hope you never do, but if you do end up in some sort of a contentious proceeding with another company that has their own IP, it gives you bargaining chips that you can use. Some types of IP that we're going to talk about today are not what people traditionally think of, patents, but they might be goodwill creating things like trademarks that associate your brand or your service with your products. And so all of these things can be gateways to getting funding, to protecting your minimum viable product, preventing people from knocking that off directly and creating positive cash flow for you. And these last two bullet points, the secret sauce and the unfair advantage in the marketplace, that really means when you've come up with something new that differentiates you from what came before, how do you stop somebody else from just taking that and running with it? Somebody who might have more resources than you or more experience in the industry, and keep it so that you're able to develop it yourself.
Perfect. Well, there are 4 avenues to gain the various benefits that Dan just mentioned. We'll talk through each of them, starting first with copyrights. Dan, back to you.
Yeah, and copyrights are the one that most people, you may not realize, but you actually get it almost automatically, or in many cases automatically. Copyrights are created as soon as you fix your work in a tangible form of expression. So as soon as you've written that code, or as soon as you've created your artwork or whatever you might be creating, those things are copyrighted, whether or not you actually go through the extra step of registration. And we do recommend for a lot of folks that you register something as a way to prove that you were the first creator, or to get more damages if somebody copies it. There are some statutory benefits that make it so if you ever did have to enforce your copyright, it would be a lot easier for you to collect some sort of real money for that. But you don't have to. And so as soon as you create those things in a tangible form of expression, you have the right, you can exclude others from copying it, selling it, displaying it, or performing it. And the other nice thing about copyright is that it lasts for a really long time. As shown at the bottom of that slide, it's the life of the author plus 70 years for a copyright. So a lot of the things that we'll see on the next slide are items that are currently just leaving copyright. Steamboat Willie on the bottom right there is just leaving copyright, or just left copyright, I should say, in 2024. This year we have A Farewell to Arms by Ernest Hemingway. So there are some really old things that you might not realize are still protected because copyright lasts such a long time. And it's a narrower form of protection. Copyright really just covers exactly what you put on the page, but it can start to get broader, such as with Harry Potter on our bottom left there, to cover fictional personas or things like that. James Bond, the idea of James Bond is covered by copyright, even though it's not the literal words on the page of a James Bond movie script. So copyright, is something to think about. You might get it for free, you might get it automatically. And if you're careful with how you use it, you can actually expand it to be a very long-lived and broad form of protection.
Yep, that's right. Next topic is trademarks. And I like to think of trademarks as branding a product or your company. And trademarks can include things such as words, phrases, symbols, designs, colors, even smells can be trademarked. For example, Dan mentioned that J.K. Rowling has the copyright to the books of Harry Potter, but Warner Brothers actually has the trademarks to the name Harry Potter, like this. This is just did a quick trademark search. And Harry Potter is owned by Warner Bros. For the name and this logo for specific types of goods listed there. And one of the benefits of a trademark is that it can protect consumers from confusion of the product. And another benefit is that the term could potentially be forever, not quite as long as, well, sorry, not as short as trade or copyrights that have a defined term of life plus 70 years. But the term of a trademark could potentially be forever, provided that the trademark is used and the goods and services it covers are used continuously and are non-generic. And so non-generic is a term of art. It's important though, because if a trademark name or phrase becomes the common term for a product or service, rather than being associated with a specific brand, the trademark can be lost. So certain examples of trademarks that have been lost are aspirin or chapstick, or even the air fryer. Some close calls I listed here are Kleenex. They were able to maintain their trademark. Things like Google. This actually was a court case in 2017 where the court ruled that even though the public uses the word as a verb, you know, Google it, there are other ways to describe a search engine. So I'm going to look on the web. It doesn't always have to be I'm looking on Google. So the court actually ruled that Google had retained its valid trademark. Another interesting part about trademarks is that the brands can be similar. The trademarks can have similar words, such as Delta Airlines or Delta Faucets. However, if the services or goods protected by that trademark are non-overlapping, that's okay. Now, brands can also coexist where the names are so similar and the products and goods and services covered by the trademark are also similar. So for example, Alpha and Alpha Wear are actually own or clothing product lines based out of Virginia, I believe. And those trademarks actually can coexist because the owners of those trademarks entered into a coexistence agreement that allowed them to continue to sell their product under these trademarks without the risk of any lawsuit for trademark infringement. And lastly here, before I leave trademarks, I want to mention a fun fact about Amazon making and breaking trademarks. This happened earlier, about 2015 or 2016, where Amazon required the consumers, the e-consumers, to be able to be listed as an Amazon brand to have a valid trademark in the US. And so all these companies started producing trademarks and filing for trademark protection to sell products. And so that's why when you're shopping on Amazon, you may see that a clothing line has words that are not really real words that would make sense. And so because Amazon required this, everyone was filing for trademarks and getting protection for words that weren't very similar anywhere else and getting them granted really easily and then able to then sell them on Amazon. And I think they've cut back on that a little bit by requiring other restrictions on e-commerce, but it's just a fun fact about trademarks. Next is trade secrets. Dan, you want to take this one?
Yes, sorry, I had my mute on there. Yes, so trade secrets are our third type of the four main categories. Trade secrets might be something that you think of or have heard called know-how. The two are related, but not quite the same. Trade secrets are another one that it's good to think about in early stages. We have the Coca-Cola logo up there because that's what most people think of as the super secret recipe of what goes into Coca-Cola that, you know, nobody can reverse engineer, nobody really knows what's in there. You know, different parts of the recipe might be kept in different safes in different areas with different people who can access them. And trade secrets, if you take adequate precautions to protect them, like a trademark, they can last forever. And there's always the question then of, well, what do I need to do that's enough to protect it? And that's sort of subjective. It might depend on what the secret is. If it's a recipe, obviously Coca-Cola has pulled out all the stops to keep all those parts separate, but you can have things like methods where maybe one part of your process is known by one engineer and another part of your process is known by another engineer, and you don't share that knowledge in one place. You mark your records as secret. You keep them away from people who don't need to know those things. There's all sorts of factors that can go into deciding whether you've adequately protected your trade secret. But trade secret, if done right, you don't have to register it. You don't have to give it away to anybody. You don't have to publish it with the government like you do for a copyright or a trademark or a patent. And so it can be a really powerful way to protect your innovations. There's a fun story about trade secrets that that has actually come out in the last few years. I think about a decade ago. White paint is made by a very highly protected trade secret for how titanium is used in mixing together the pigments that make the white paint. And DuPont has kept this secret for years and years. And one of their former engineers tried to not only take documents related to how to do this, but was chatting in an email that actually came out during the court case with another person who said, even with the best technology and with stolen prints, but without startup people and maintenance expertise, the plant won't be successful. That's a direct quote. Even with the stolen prints, we won't be successful. And so he approached a staffing agency to hire up a bunch of former DuPont engineers to get the right combination of know-how. And that was found to be trade secret infringement. And that former engineer is actually in prison now, a 15-year term. So most intellectual property we talk about, it's monetary fines, it's penalties with dollars. But some of this trade secret stuff can have some serious teeth to it, prison time, and it feels very cloak and dagger. So it's a good thing to get set up. It's very powerful. It's relatively inexpensive when you've got a group of 2 or 3 entrepreneurs working together to figure out how you're going to share that information between yourselves and not share certain information between yourselves.
Our last form of IP is our bread and butter, patent applications. So patents, once granted, give the owner the exclusionary right to prevent others from making, using, selling, or importing whatever is protected by the patent. It could also be used, though, to permit others through some sort of license agreement or grant of rights to then permit certain people, but specific people that you've granted those rights to make, use, and sell those products. And so patents, once granted, the government gives the owner the right to enforce their rights against others to stop unauthorized use. Patents are not actually a government enforced monopoly. You still have to enforce that against someone else. There are 3 types of patents: utility, design, and plant. And so what's shown here on the screen is a drawing from a patent for a toilet paper roll, which was patented many, many years ago. But one of the benefits of patents for at least a utility and plant patent is the term is about 20 years from the filing date. I have an asterisk here because we'll talk about some of the nuances for design patents in a second. But for a utility patent application, there are several strategies for filing. So one common strategy that we see and recommend sometimes is filing a provisional application prior to converting or using that provisional application to file a non-provisional application. And one of the benefits for this strategy is that provisionals aren't actually examined by the patent office, and you can submit any form of informal documents to set your date for that you have filed your patent application. So anybody that has a similar product to yours or tries to file a patent on it, anything that they do after you will not be considered or reviewed during examination because it came after your date. So informal documents can even be something if you're presenting on your research on at a conference, you could submit those slide deck or the poster presentation, you could submit that to the patent office, and that is a sufficient provisional application. However, the provisional does expire 1 year after filing, and so at that point, you need to decide if you're going to convert the provisional into a non-provisional. That's when the examination would start with the patent office, and that does require the formal documents. So the formal documents will require the claims, the full specification, and an oath and declaration from the inventor. And those non-provisional applications will expire 20 years from the filing date. One thing to note, though, with provisionals, whatever you provide in that application is what you are protecting. So if you only provide a poster that you're presenting on, but then you change things throughout the year, whatever you change and add to it wouldn't be protected by that original filing of the provisional. So you want to make sure that you include new updates to your inventions and follow-on provisional applications before you convert to a non-provisional. And this is obviously a case-by-case basis on the invention, but this is just one common strategy that we see. And so for design patents, I'm going to toss to Dan.
Yeah, design patents are kind of a special animal in the patent world. They are just like utility patents. They're issued through the same patent office. But what they cover is not the utility of what you create. It's sort of does what it says on the tin, right? So it's not utility of what you've created, but it's design. It's the design itself. So it's defined by the drawings that you submit with your application. The words still matter, but it's very short text and it's very heavy on the drawings. Designs are also unique in that they last 15 years from the issue date. So it's not like a utility patent where you are losing term during the prosecution process, which with a utility patent can take 2, 5, 10 years. With a design application, you get the full 15 years from the issue date. The two patents that are up here, the design patents shown on the right and left of the screen, those belong to Apple, and they actually correspond to the iPhone 1, or just the iPhone as it was called at the time. And you might remember from back in the day, there was a famous lawsuit between Apple and Samsung about rounded corners on apps. And Apple and Samsung got into a lot of patent fights around that era, and the utility patents were, getting enforced for a few million here and there, back and forth, and that's pretty typical for utility patents. And then this design patent got enforced, and the damages award in favor of Apple was over $1 billion. And it was all about these rounded corners. And I think design patents got a lot of attention around that time, because if somebody infringes your design, unlike utility, so you make a processor that runs a little bit faster or a battery that lasts a little bit longer, the amount of monetary award you get from a court corresponds to what percentage of the value of the device that you've taken that was patented. What portion of that do you need to give to the patentee? So it might be, on a phone, it might be 0.1% of the sale price of the phone is based on your improvement to the utility. But with design, it's the entire profits. And so designs are interesting because they are this enormous cudgel to prevent people from taking the design you've made. They're also very narrow, because all someone has to do is, say, take your rounded corners and make them sharp, and they no longer infringe your design patent. So when you've got something that's very, very specific, this is my graphical user interface, for example, I don't want somebody to take that exactly the way that it looks. Or if you've got a product that has a distinctive shape, ornamentation, surface coatings, all those kinds of things that affect the look and feel of the product rather than how it works. Designs are a great way to protect that very narrow scope, but with a very high level of protection.
I mean, this is a question we get often. Is software patentable? Would recommend someone, use a design patent on a portal they
Yeah.
have developed?
And I always hesitate to answer this question on anything that's recorded, because the answer changes from time to time. It used to be the case that almost any software was patentable. In the 90s and even early 2000s, it was possible to get patents on almost anything because software as a concept was new and shiny and everybody was making creative things using software. We started to see the courts get a little more skeptical of that in the 2000s. And in the mid-aughts to 2010, there were several decisions that really clamped down on the ability to get software patents. As a strict rule, software per se, no, not patentable. However, there are a lot of exceptions to that rule, and areas where courts have now said, well, but an improvement to how a processor works using code, that's not really software, that's an improvement to a practical application. Ways of manipulating data, we're seeing a lot of patents on LLMs and other AI tools. And so the pendulum has swung at least back to the middle. So software patents are now their own unique creature. They require some specialized skill to know how to prosecute them through the patent office, but they are absolutely, as of 2025, patentable.
Perfect. So a question that many startups face, and you might be facing this right now, is should I get a patent? And this is ultimately a business decision. Some of the points that we discussed with startup clients that we commonly go to are what's the value and the ROI, the return on investment of your invention. For example, software, I like to think that softwares change pretty frequently. So if you have a software product now, it may be modified in a year or two. So would patenting that current iteration of your software bring any value to you if it's just going to change? And what else is out there like your invention? Is it easy to copy it or to design around? If it's easy to design around, that might weigh against getting a patent on your invention. Other questions are like, what is the market like? Will everyone that uses the internet like to use your invention, or is it more directed to a smaller group of customers? And another question is, will your product infringe another person's patent? And so that's what Freedom to Operate kind of assesses to see, is it likely that you might get sued by somebody that has a patent similar to the space that you're trying to develop in? So it makes sense, though, to discuss what the requirements for getting an invention to be patented, as this is something that, as patent attorneys, we come across this in our daily activities, something that we're thinking about as we're meeting with you to discuss your invention. And as if you know what's entailed in the process, it makes it a little bit easier for you to get involved in helping protect your invention. So one of the requirements is the invention patentable subject matter. So these are required by statute. It needs to be a process, machine, manufacturer, composition of matter, method of making, method of using, or any improvements to the above. So this includes most things. However, there are some carve-outs that have been decided by courts. Certain things that cannot be protected are laws of nature, such as gravity, or this, I'm blanking on the word, but the pendulum that never stops. But laws of physical phenomena are also unpatentable, and abstract ideas. So for example, if you just have a new mathematical equation, that alone is not patentable. However, if you're able to use that mathematical equation to do something more with it, to create some sort of outcome or product, that may be patentable. So there are ways to take what's not patentable to turn it into a patentable subject matter.
For the next puzzle piece in our set of 4 here for the requirements of the invention to be patentable is written description. Earlier, when we talked about trade secrets, I mentioned you don't have to give away the part of your invention that that is new and special and different when you follow that route. In the patent route, though, you do have to give it away. So you can think of this as the exchange that you're giving to the public, and they give back the right for you to commercialize that exclusively for 20 years. So written description, you have to actually tell the public what your invention is, how to make and use it, and you get the right then to stop everybody else from doing it for 20 years. But once that 20 years is up, it belongs to everybody.
Yeah, that's right. One of the other next steps is novelty. So for novelty, I like to describe this as whether there's anything out there in the public that covers all elements of my invention. So public knowledge can come from any form of public disclosure. I listed several of them here, but this is not exhaustive. So if something is publicly known, it's published and can be found. However, there are times when you're talking about your invention and it's private. It's not published anywhere, and maybe it was just discussed internally or through some sort of confidentiality agreement. That would distinguish that from publicly known. So if it's been kept internal, it would not be public. This is very different from the element of non-obviousness, which is honestly where a lot of us patent attorneys spend most of our time working on getting things to become issued.
Yeah, and non-obviousness, or you might hear about inventive step is another way to describe it. This is really more subjective. What would have been obvious for somebody to put together at the time you made your invention? So if peanut butter was known and jelly was known and bread was known, would we necessarily put those three things together to get the peanut butter and jelly sandwich? And we spent a lot of time talking about, you know, what did trade publications in your area say about, this will never work, or how long have people been trying to solve the same problem that you tried to solve and being unsuccessful, and all sorts of other subjective factors to convince the patent office that what you've come up with not only is a combination of known parts, but is a non-obvious combination of known parts.
That's right. Oh, my clicker stopped. Okay. So this is the fun part of this presentation. This is what I love to do every year. I come up with a new invention. And Dan, I'm coming to you this year as my patent attorney. I've hired you and I want your help in determining whether I could or should file a patent application on my invention. And I find this part of the presentation to be helpful for those that are curious on what the tech transfer office professionals are doing when they get your invention disclosure. But also if you're outside of the university setting, maybe some things that you can do on your own to determine if you should and when you should talk to an attorney, because this could help you reduce the cost. These are things that we do internally all the time. So if you have some of these tools in your tool belt, it could help you in the long run. So this year though, my invention, I've been thinking about ways to become an ultimate multitasker. I want to exercise while I work. And everyone already knows that you can walk while you're working using a walking pad. This is actually what I was doing when I came up with my invention. And there's also people that do biking while they work with these bike pedals for your desk. But when I was thinking this, what about people that are training for a triathlon? That's not me. I'm not doing that. But what if, there's my market. What if people are wanting to train for swimming while working? How can we do this? And so I created a working station desk that will allow you to swim while working. So what I did is I found a way to mount onto a dry swim machine, and so I don't have to use my keyboard because my hands are going to be rowing. I have these handheld keyboards that will fit into where my hands go, almost like a glove. So I did my own searching real quick. Ta-da! Here's my invention. I did a quick search, and on the web, I don't see anything like it. There's something similar. So this ultimate workstation for those that want ultimate comfort. It looks very comfortable, but it won't help me with getting to my ultimate goal of being a triathlon or a millionaire by selling this product. So I did see this creative lounger here, but this isn't helping that person learn how to swim or work on their swimming. So ta-da, this is nothing like that. There's nothing like this. Dan, as my patent attorney, should I do a patentability search next to see what I should do? See if anyone's filed something similar to this, see if I have the ability to file a patent on this.
Well, the good news is you've already started your patentability search because you've already found your walking desk and your cycling desk. And so you've already found some of those pieces, the peanut butter and the jelly, and you found the glove. So you know what the parts are, and you can almost anticipate from your patentability search that you've done so far that you'll get some sort of inventiveness or obviousness challenge from the patent office. 99% of the time, or maybe 95% of the time, your first office action is going to be a rejection where the patent office will tell you that that your claims are too broad and that you can't have everything that you've asked for. In fact, as patent attorneys, if we get everything we asked for in the first round, it probably means we didn't ask for enough. But the benefit of doing a more thorough patentability search is that you can prevent yourself from running into further dead ends. For example, if we search a bit more, we might find that people have put some of those pieces together already in ways that you might not know about. They may not have ever commercialized the product. They may have just published about it or tried for their own patent application on it. So that's the real benefit to your patentability search, is making sure that you don't end up chasing a route or chasing towards something that's going to end up getting rejected on that basis. You can also sometimes find things in a patentability search that will give you what we call freedom to operate. So maybe somebody else has had your idea, they filed a patent application on it, and that patent is expired, or they never got it issued, or they gave up midway through prosecution. And then that invention has already become the property of the public. And if that's the case, your patentability search might actually lead you to the conclusion that you don't need a patent at all. You can just start selling your product. So we don't recommend spending a ton of time on patentability searches because at the end of the day, if you do file a patent application, the examiner will also search your invention. But it can be a good way to direct the scope of your invention or the scope of your patent application if you decide to proceed.
That's right. So I wanted to provide some tips for doing your own patentability search if this is something that you want to do, or this is what I used to do when I was in the tech transfer office. So this is how I would evaluate your inventions. I would first search for similar products on Google, like I showed you before. But if you want to dig deeper, you could actually do some searches on some patent databases. And there are several free ones. The ones I listed here are all available for free. SciFinder needs a subscription, but I think Emory and Georgia Tech both have subscriptions to those if you are a faculty or student there. Patent search companies could also be hired to do pretty quick searches for you. And then you can also hire professionals and law firms to do the same. Some ways to do a search, and we'll walk through searching for my invention, but you can use Boolean syntax. You can also use wildcards. These are all different examples of things you could use while on Google Patents. And so I'm going to walk through what I did here for searching for my invention. Excuse me. I searched for initially just this swim machine desk that generated a lot of results. I'm sorry, I need a cough. And then I also searched for, man, this is the daycare gets you. I also enhanced my search by searching for things in the claims. So here I searched for exercise and desk in the claims. And I noticed when I was doing Google Patents that the word desk without the quotation marks pulled up words such as table. So that wasn't helpful for my search. Oh, excuse me. So from this review, I did find a document that seemed to be relevant. In the patentability search, you want to actually look at the whole document, not just the claims as you do for freedom to operate. So these are some words that came out from my search. And so this document seemed to be relevant. So Dan, now that I pulled up this document for you to also review, what else should I consider doing as a next step?
Yeah, well, one of the things that we think about in addition to publications is anyone else who might have, or anyone else you might have sold your invention to or talked to about your invention. Oftentimes it's necessary to talk to people prior to filing a patent application. So you might talk to an investor, you might talk to a manufacturer, you might have employees or collaborators that you work with. People who might put together CAD drawings or something for your new device if you're not comfortable doing that yourself. So there's a lot of non-written disclosures in addition to what we find in a prior art search. And all of those things can count against you at the patent office, and you're required to tell the patent office about them. So when you talk to those people, you'll want to consider confidentiality or non-disclosure agreements. You can file those provisional patent applications that we talked about earlier to cover proto versions of your application. There's certain strategies for that. If you're going to go into a big investor meeting and you think they're likely to take your idea and run with it, sometimes just getting a rough provisional on file prior to that meeting can be helpful. But yeah, think about before talking to your mom or your neighbor about your invention. It's a little awkward to ask your neighbor out by the trash bins to sign an NDA, but sometimes it's easier to just keep that quiet until you've got your patent application on file.
That's right. And other reasons to consider filing for a patent application, as Dan mentioned, the on sale bar. The US does allow for a 1-year grace period for you, the inventor, to file your invention with the patent office. However, if someone else, say someone from this presentation, takes my working swim desk and files a patent application, someone else's filing could actually destroy my novelty. The foreign rule is for most countries that they require absolute novelty. So that means no publications by you or anybody else prior to filing. So they do not give you a grace period. So in general, I think some overall tips and tricks are keep your invention secret or use confidentiality agreements. You can file for an application, get your priority date set, and start obtaining your protection. And then once you do file it, you can start marking it as patent pending. So I do want to mention a little bit about inventorship because this is a common question, especially when it comes to university-based research. So Dan, I'll let you take it from here.
Yeah, this is a question we get a lot. I think many people coming out of a university environment think of inventorship and authorship as the same. Sarah, I think your scratchy throat has transmitted to me.
I hope not.
So inventorship and authorship are really quite different things. And so even if you have an academic paper that might list several authors, the inventors may not be the same. Order of inventors doesn't matter in the same way that authors do. It's really who came up with the idea in the first place, who conceived of the idea. People who implement that idea or do testing or do data analysis based on the idea are not inventors. The other thing that is an important wrinkle is that inventorship and IP ownership are not the same thing. So you may have one or more inventors who are owners and some inventors who are not owners of the IP, or you might have the ownership of the patent sit in a corporate entity or the university or whatever it might be. And so keeping those three things in different buckets conceptually of who's an inventor, who's an owner, who's an author. Inventorship really doesn't matter too much when it comes to, as I say, like ownership and who gets to commercialize the invention. So our overriding concern is just to make sure it's correct, because a patent isn't valid unless the inventorship is correct. So we always want to make sure that we get to the bottom of who came up with the idea and get it right in the filing.
Yeah. And just to summarize, the inventorship, co-authorship, distinguishing features. So inventor is going to be under patent law and co-author is going to be a copyright law issue. And so, as Dan mentioned, those that may have contributed to the invention, but did not actually help with the contribution of the inventive step may not be considered inventors. Whereas when you're writing your research papers, anybody that contributes to that paper or the research would be considered a co-author. And then also with ownership mentioned by Dan, this is very important, especially if you're in the university setting. This is likely going to be covered under some sort of employment agreement that you sign when you started there. Most universities, if not all universities, will have an IP policy that sets forth your rights as an employee and what happens to the inventions you create while you're there. One thing to consider is if the invention is within the scope of your employment. Sometimes there's been some cases where universities are willing to say that what you created was not in the scope of your employment or not during your time at the university. So was the invention created during using employer time or resources? That's another question that some universities will look into. But again, an inventor, you're still an inventor regardless of who owns the patent. So that's something to keep in mind to distinguish between inventorship and co-authorship. So Dan, should I look into anything else to make sure I can sell my product after I, create it and test it out, of course?
Yeah, and I wanted to add as well, and hopefully the tech transfer folks on the line won't be kicking me under the electronic table for saying this, but universities are usually pretty happy to work with entrepreneur inventors and really have a desire to see technology get put out into commerce. Universities are not well, there are some, but most universities are not for-profit institutions. They are happy for you to run with inventions as long as you do everything according to the rules. And so don't be afraid to call up your tech transfer officer. They're not going to, not legal advice again, but they're not going to try to steal your invention. They're not going to try to pull the wool over your eyes. They're really, really great resources for you. But yes, turning to the question that I was actually asked to answer, for avoiding infringement, usually when you're in a startup phase, a patent landscape can be done that's pretty rough. You don't really face a lot of potential damage for infringing until you start actually selling or making products. And so for a lot of startups, there's just not a whole lot of risk that is on the table until you really start to ramp up and start commercializing things. So it's not zero, but it's usually not worth doing an enormous landscape, for tens or hundreds of thousands of dollars in attorney time. It's just not the best use of your resources in the startup phase. It is good to have a little bit of knowledge about the landscape, just so you're not directing your commercialization efforts into a trap. And so it's worth looking around, but as an entrepreneur, you probably know who your biggest competitors are going to be, who your biggest licensing opportunities are going to be, and keeping an eye on what they're up to in the patent world and in their products is going to be really helpful. As a patent attorney, I love it when my inventors come to me with that kind of information. We have all kinds of tools we can use to monitor for new filings and keep track of news about SEC filings and all kinds of things from big competitors you might have. So patentability investigation, we've talked about a little bit. That can be another way to avoid infringement, because if you do your patentability search and you find out that there's a valid patent with claims that exactly map onto the product you want to sell, that's a conversation we're going to have. And so you get a little bit of a double benefit from that patentability search.
That's right. So I did find this patent though, and I remember I mentioned that it was similar, and it has some claims that I was worried about, but I did find some things that were different. So I highlighted the things that were different in red, and I mean, it looks like it's pretty clear to me, but maybe a patent attorney would have a different assessment based off of their knowledge of how to evaluate the patent based on definitions that may or may not be present in the rest of the application to help that would define what these elliptical trainer or 2-foot assemblies mean and how those are used in this invention. Do you think I should
Yeah.
put in my invention?
No, that's exactly right. Everything with patent claims is a little bit of a gray zone. There's an expression that I don't remember where it came from, but I love to use, that every word in a patent claim is a potential traitor. And so when you've got 2-foot assemblies, well, could your hand paddle keyboards, could somebody put those on their feet? I don't know. Somebody might assert that they could. There's people who can do paintings with their feet and all kinds of things. So maybe they could be used as foot assemblies. Whether that's the rear end of the frame depends on your perspective. So, it's something we would look at, but on the whole, those are pretty wild assertions. I think based on this patent claim, you're likely going to be in the clear. But we would keep an eye on, again, what is this applicant up to? Are they still making products? Are they trying to get into the desk triathlete space, just to be safe?
Good to know. Good to know. So I'll take it back to the my garage and think more about it before I do anything with it. But or maybe I'll just use it for my own use. So
Yeah.
see. With that though, we are done with my invention and all the background of IP that we wanted to highlight today. We're going to open up the floor for questions, and we also inviting Kashmir and Caitlin to join us as well.
Awesome. Thank you, Sarah and Dan. And I butchered your last name when I introduced you, Dan, so apologies for that.
Nice.
Yeah, so if you have questions, broad or specific, feel free to put those in the chat or in the Q&A function. All 4 of these experts are here at your disposal, and you don't have to pay a lawyer for this for these 10 minutes. So use your time wisely. I'll just start while we're waiting for folks to have questions. First, Sarah, that was a great tidbit about Amazon and why all the weird Amazon names are there. I did not know that. That is so fascinating.
I know. I love fun facts about IP.
That is a great fun fact. My wife and I are always wondering, why is it the WXZP blanket?
That's right.
Yeah, I didn't know that either. That's interesting.
Yeah. I have maybe a provocative question right at the beginning, which is, what is the biggest mistake that you see, specifically academic inventors, when they come to you and you're looking and you're like, ooh, we have an issue here? What is the sort of the ooh that you're seeing from academic inventors that they can try and avoid?
The thing that I can start, but the thing that I would say in terms of that is, if there's a publication that occurs and we don't know about it, or the publication date is incorrect, like if a paper is pre-published before, like we were told that it was going to publish, just like issues around publication and making sure those dates are correct so that we have time to do an emergency filing if we need to before that publication occurs.
That's right. I'll piggyback off of that, Caitlin. I remember prosecuting a patent application once, and we didn't find out till the examiner brought it up that one of the students of the researcher had published it in his dissertation before we filed for the patent application. So it became a really big hurdle to distinguish what was in the dissertation versus what was covered in the patent application. So that was problematic.
Yep, it's worth repeating that like literally everywhere we go. If you are going to present your idea at a conference, at a paper for the first time, contact your representative at Georgia Tech, UGA, Morehouse, Emory, whoever, wherever school you're at to disclose that. There's a specific phrase that Caitlin or Kashmir will correct me on. I think it's like a cover sheet provisional or like a fast, just get you protected.
But to Sarah's point about the cover sheet, the limit of protection only extends to what's in the provisional. So if a provisional is not of good quality, you can't really expect good protection. So always bear that in mind. While quick is great, it may not always be good in the long term.
And something we didn't mention in the talk, so provisionals aren't going to publish, but you can still find them if they've been converted to a non-provisional. So patent attorneys will know if you're trying to get coverage for something that wasn't actually in your provisional. Patent attorneys have ways of finding that and making sure that if you even do have coverage for it.
Good point.
So Morgan, one point just to add to the previous discussion about presentation and work. No academic institution is going to stop academic exchange. So if the exchange of ideas is with collaborators who you intend to work with in an academic setting, we're not going to say you need to have an NDA be put in place with every lab that you intend to work with to develop your IP, right? So I think this is, again, a discussion to have with your tech transfer office when you plan to engage in conversations, which would include developing a project for a long duration. Who's going to be involved in that conversation? Is it going to be academic partners? If it's going to be an industry member who may want to join in and support that project. So that's a conversation to have with the tech transfer office for sure.
Awesome. Good addition. I'm going to go to a couple questions now. And I'm actually not totally sure of the context here from Stu. What is the benefits in licensing versus non-licensing a patentable product? Does anyone follow that question?
I think there's two things that gets at. It could be one or both. You could be licensing from someone, or you could be licensing to someone. I have at least a couple of clients who license a lot of fundamental technology from universities, and putting together those pieces. You might have one lab at one university that's really focused in one area and another in another area. Licensing those things, I think, is something that a lot of people get discouraged too quickly. They say, oh, somebody's already got the patent on this, I guess I can't do it. And I think that's a little hasty. I think people tend to be hasty with it, and especially where the applicant or the owner is a university. Like I mentioned earlier, most universities are happy to see their technologies get commercialized. So I think if you have a product, you see that there's a patent on it, and you still want to proceed with it, it's worth at least reaching out. And then on the flip side, I think if you come up with something that's new and different and great, and you don't necessarily have the resources to commercialize it yourself, having the patent means that you can work with other companies, of course, that do. So if you come up with the next great phone and Apple wants to license it from you, that's fantastic. You don't have to do it yourself. I think there's a lot of landmines there to navigate as far as making sure that you negotiate your license well and get a good deal and make sure that that the product actually gets created and commercialized in the way that you want it to be, and that you're not just giving away exclusive rights to your patent to someone who's not actually going to do what you want with it. But that's really the benefit of having a patent, is that you get that exclusive right and you get to decide how it's used. It doesn't have to be you who uses it, but you get to decide how it's used.
Awesome explanation. I'm gonna take the next question here, also from Stu, which is, does a person have to be a current student in order to take advantage of partnering with the tech transfer office? And I'll say something generic, and Caitlin and Kashmira, please correct me if I'm wrong. Basically, the way that if you are an employee, then the university basically owns your intellectual property per your employment agreement. And if you're a student, it's a little bit in a gray zone, depends on the kind of student. And the rule of thumb I tell people is follow the money. If you are paying to be at the university, you probably own all your own intellectual property. And so the tech transfer office actually doesn't come into play. You know, they will help you, they'll support you, but the university does not own your intellectual property. If the university is paying you, then the university probably owns your intellectual property. Check with them to be sure, but basically follow the money. Okay, last question here, tricky question, maybe or not. How do you secure product designers and manufacturers, and how do you, that's a long, deep question, and how do you prevent them from stealing your device idea? Who wants to take that?
Yeah, I wish I had a good answer. I hope somebody else does. You know, finding folks, there are often for example, up in Minnesota, there's a retired executives group that will help entrepreneurs find good contacts for manufacturing. I'm not sure if similar things exist. I'm sure they probably do in Georgia as well. You know, you're never going to have 100% certainty. That's part of what IP is supposed to help you protect, is that if somebody does run off with your idea, that you can stop them. But I think the last thing that a lot of startups want is to have to bring a patent infringement lawsuit while they're trying to commercialize a product. So it's a really tricky thing to navigate.
So I'll throw in just a bit of generic advice, which is, you know, patents and NDA documents, those are all things that protect you and make you feel secure. And you should do those in the appropriate situations. However, I would also rely on some basic human intuition, like reputation. You know, if it's a random company you've never heard of that doesn't have a website and you don't feel comfortable, then trust your gut not to share stuff with them. If it's a large, you know, contract manufacturer that, you know, is well known and comes recommended to you, then I would feel less worried about them stealing your idea. And so I would, you know, that's my basic guidance to people. But yes, they could sign an NDA. I'm curious, Sarah and Dan, what you think. NDAs I find to be, they make you feel better. I don't know how much they really do, frankly. But you know, if someone's willing to sign an NDA, it does tell you something about their reputation, that they're not going to steal your thing.
Yep, I think the one piece of advice I would not, it's not legal advice, but one thing I would say is if you are the one sharing the information, make sure it's a one-way NDA, confidentiality agreement, and not mutual confidentiality agreement, so that you're not on the hook for retaining any information they tell you. Sometimes having those NDAs in place could be helpful if you ever do need to take action against somebody, even if they haven't sold your invention yet or anything like that. Any type of foul play, you might be able to get a state law claim against them for breach of contract at least, or just have a little bit of more of bargaining chips with after you bring an attorney on to help you settle any type of dispute that may be happening.
Cool. Well, thank you, Dan. Thank you, Sarah. Thank you, Kashmira. Thank you, Caitlin. I appreciate you all being on and joining us. Everyone that's attending, I have the slides from Sarah that I will send out to everyone, as well as the recording when that's available. So thank you all. Have a good rest of your day.